With our school budget so tight, it is unconscionable that the board plans to approve a new contract with Chari Chanley that will give her a raise to $246,000 by the year 2028. Ms. Chanley has had multiple ethics complaints filed against her, and as far as I know, none of these complaints have been dismissed in their entirety. Now Ms. Chanley is demanding a raise because after 20 years of enrolling in multiple doctoral programs at taxpayer expense, she has finally achieved the doctorate. Yet the district refuses to release a copy of her diploma. Furthermore, although her full dissertation is not yet public, the abstract of her dissertation is public. In this abstract, Chari Chanley describes herself as previously a quote-unquote dictator of a middle school. This raises questions as to whether the board thinks dictatorship is an acceptable leadership style for a superintendent. On April 24th, 2023, Ms. Chanley filed a lawsuit against me a week before I was scheduled to testify against her before an administrative law judge in a case in which she has been accused of abusing the tuition reimbursement policy. Chanley alleged that I quote-unquote invaded her privacy by reporting that she took a taxpayer-funded trip to Disney World. In court documents, Chanley described this trip herself as a quote-unquote family vacation, although she was purportedly there to attend a professional development opportunity that was board approved. Chanley also charged me with quote-unquote torturous interference of her contract with the Monroe BOE, claiming that it was my fault that the county superintendent, Kyle Anderson, refused to recommend her for the acting superintendent position in the fall of 2021. In her lawsuit, Chanley provided no evidence at all to substantiate any of these allegations. On August 25th, the judge dismissed all these charges against me. However, there was one count of tortious interference he allowed to proceed. It was Chanley's allegation that I was making it difficult, if not impossible, for her to achieve a doctorate. However, after Ms. Chanley allegedly achieved this doctorate and was unable to produce evidence that I played any role in delaying this achievement, she tried to withdraw from the lawsuit. But I did not permit her to withdraw without filing the evidence that proves my innocence. This evidence was filed with the court on November 9th and includes copies of her official transcripts and communications with Rowan University that was released by the Office of Administrative Law in an OPRA request. On December 4th, this case against me was dismissed in its entirety. As a public official, in a highly visible position, the public has a right to comment and criticize the job performance of a superintendent. Moreover, such public participation is protected by the law because it is essential to the functioning of a democratic society. After filing this lawsuit, Chanley failed to intimidate me, and I testified against her anyway. She failed to silence me or limit my First Amendment rights, and she wasted a ton of money in litigation against me in a frivolous lawsuit that has been dismissed. Perhaps now she wants a raise to pay off the legal fees that she incurred in this baseless lawsuit against me. Why is the board approving this raise without requiring Chanley to release her diploma? Other municipalities have released diplomas in response to OPRA request. Why not Monroe? Why doesn't the board require Chanley to provide evidence that she underwent professional development in Orlando before paying for her airfare to Disney World? Where is the accountability and transparency?
Thank you for your comments.
So you have no explanation as to why you're not responding to the OPRA request about her diploma?
No, thank you for your comments.
Or why you're not requiring her to prove that she attended professional development in Florida? No explanation to why these OPRA requests are denied.
Did you go to Disney?
No, I did not go to Disney.
Why not? She went. It's nice.
All right, thank you.